Welcome. Welcome to this new discussion of the Dynamic Antitrust conversation series. Today, we're going to discuss about a new buzzword in the antitrust community, in the antitrust debate, self-preferencing. What does it mean, and why is it so important to allegedly ban, as some antitrust bills suggest, this practice of self-preferencing? Self-preferencing is a business practice that encompasses many aspects of the business life. Self-preferencing can be for a supermarket or for some online platforms to favor their own private labels over the product of other companies. It can be for a smartphone company to have pre-installed apps. It can be for a software company to have some pre-installed software in its computer. It can only be these related to tying, where you self-prefer an adjacent product from the main market. So self-preferencing is quite new in the antitrust debate, and we haven't really had this word for the antitrust history. And it's very hard to try to define the limits, the boundaries of self-referencing, and also to explain why the harsh stance against self-referencing currently dominating is justified. And to understand this concept of self-referencing and what would be the optimal antitrust approach to self-referencing, I have with me Professor Herb Hovenkamp, who is professor at the University of Pennsylvania, who is well-regarded and widely respected figure in the antitrust community. It's needless for me to introduce him. Herb, thank you very much for being with us. It's a pleasure to have you and to start this discussion on a very hot topic on self-preferencing.
Thank you very much for having me.
Thank you. So ITIF has just published a report on self-preferencing, where we try to define self-preferencing. But can you tell us what is self-preference? How can we define self-preferencing? And is it an antitrust violation to self-preference?
Well, first of all, self-preferencing is not yet a legal term of art. So we don't know exactly what it means. There's a whole bunch of different things that it could refer to. And as you just pointed out, there's a lot of practices that are already in the antitrust lexicon that control certain types of self-preferencing. So for example, the law of exclusive dealing regulates the extent to which a firm can exclude the products of its rivals. The United States, for example, the Standard Stations case, an old case now, 1949, held that it was illegal for Standard to impose restrictions on its gasoline retailers that required that they sell Standard's gasoline exclusively. Right. The law of tying arrangements is frequently used to police the extent to which a dominant firm can require use of its own secondary product when you purchase that firm's primary product. And the related law of tech ties does the same thing, except with self-preferencing technological designs. For example, there's a very well-known case currently being litigated through the system involving Keurig, the coffee machine maker that uses these little pods. And Keurig redesigned the pods in the machine with a barcode on them so that the machine would only accept Keurig's own pods. Prior to that, there were a lot of different companies that could sell pods, and all of them could be used. It turned out that particular act of self-preferencing ended up being a commercial flop. There was so much customer resistance that Keurig ended up abandoning it, but it's still litigating the consequences. The law of exclusive dealing deals with vertical mergers deals with situations where the concern is that the vertically related merging firms will deal in their own products exclusively and foreclose rivals. So, depending on how you define the term, there's a lot of different things that could come under the law of self-preferencing and a lot of things that are already covered by it.
Right. It's very important to say that it's not yet a legal term, right? Because it encompasses a number of practices that are very well defined, such as tying, exclusive dealing, as you just rightly say. Also, self-preferencing seems to relate to this concept of platform neutrality, right? Where you have a kind of, as the current chair of the FTC wrote in one article, the separation of platforms in commerce, you would have this very dubious claim of separating the platform in commerce so that you prohibit self-preferencing. Is something doable, desirable?
That's a very, very extreme view of self-preferencing, and I believe a very anti-competitive one, because it would ban a lot of practices that actually make retail markets a lot more competitive. I mean, in the context of Amazon, Amazon sells batteries made by third parties, Duracell, Everready, and so on, Rayovac, but it also sells its own battery line under the name of Amazon Basics. And those are sold in competition with each other. The Duracell Rayovac line is sold at a fairly high price premium in lots of different places. Amazon Prime, on the other hand, is more deeply discounted. And as a result, one impact of the availability of both sets of batteries on the Amazon website, plus very easy switching, right? If you search for batteries, you'll find both of these and you can click on whichever one you want to buy, is that some people buy Amazon Basics batteries, but it forces the prices of the Duracell and Everready batteries to go down. Now, there's a misconception, which is that Amazon's acts of self-preferencing disfavor small firms. Occasionally, that is true. Occasionally, a smaller firm may suffer because Amazon has gone into competition with it. It's not always true, and if you look at the dollar value of sales, it's true only a very tiny percentage of the time. For example, Duracell, one of the competing battery manufacturers, is owned by Berkshire Hathaway, one of the largest holding companies in the United States. A great many Amazon Basics products are small appliances like toasters and blenders sold in competition with Black & Decker, which is one of the largest appliance makers in the United States. And you can go on and on with that list, but the real thing that multi-choicing of products offers is lower prices for consumers, higher volume, and as a result, and this is something we frequently overlook, higher volume or higher output also entails more labor opportunities. We get very concerned about the impact of antitrust on labor. Well, at the lower end of the spectrum, when we're talking about hourly wages, labor is a pure variable cost. And so that means, presumptively, if output goes down by, say, 20% or so, the number of job opportunities in that market will go down. So there's lots of reasons to maintain competition on platforms, not to say that it cannot sometimes be abused. And incidentally, that same set of constraints applies to large brick and mortar retailers like Walmart or Target. Walmart's actually a bigger retailer than Amazon. We don't want to give up the opportunity for there to be competition on all retail markets, including internet platforms.
It's very important that you emphasize that self-preferencing also contribute to price competition that is beneficial to consumers. And that is also a very common business practice from retail, and that is something to have in mind. I think what you just said leads me to ask you these second questions about the vertical integration and product diversifications, because sometimes self-referencing is about diversifying so that you can enter into adjacent market and therefore kind of leverage the market power you have from the primary market in order to compete and to disrupt the traditional incumbents that are present in the adjacent market. This looks like a disruptive competition, which may be good for consumers, but at the end of the day, the prohibition of self-preferencing will limit the ability of companies to vertically integrate and to diversify their product, isn't it?
Yes. Well, and part of the neo-Brandeisian critique of antitrust has reflected a fairly deep hostility towards vertical integration.
Right.
I think a lot of it without really understanding what vertical integration is. For example, tends to see it as a monopoly problem. A solo practice lawyer who decides to throw out her own trash and wash her own windows because she can't afford to hire a janitorial service, that's an act of vertical integration. That is vertical integration into a different level of service in order to provide a good for yourself that you could otherwise purchase. So vertical integration is a very complex phenomenon, and it needs to be looked at circumspectly. One of my favorite examples is the Standard Stations case, which I told you about just a minute ago, that involved the prohibition of Standard Oil, very large company at the time, prohibiting sales of Rivals gasoline at its retail stations. Justice Frankfurter wrote that opinion, but there was an extremely prescient dissent written by Justice Douglas. Now, one of the things to understand about Justice Douglas is that he was one of the most aggressive antitrust enforcers ever on the Supreme Court. He was a New Dealer, a Roosevelt employee. Why did he dissent in the Standard Oil exclusive dealing case? It's because he said Standard is going to comply with this decree by terminating its independent dealers and moving into self-owned gasoline retailers, which is exactly what happened. That is, it became so costly for Standard to sell through independent dealers that it simply began selling for itself. And a self-preferencing rule, depending on how it's drafted, can end up doing the same thing. If it gets so difficult for Amazon to sell Duracell batteries and Amazon Basics batteries in competition with each other, Amazon may simply say, okay, we're simply going to stop selling Duracell batteries and we'll sell our own. We'll sell our own batteries. And in that case, you've basically ousted the third party from the market altogether.
And that's a great point. That reminds me an article from Ronald Coase that I cite in the report, which is 1934, The Nature of the Firm. There's a balancing, a trade-off between integrating and transacting, right? When the cost of transacting in the market are too high, you integrate, and when the cost of integration are too high, you exchange on the market. And the firms evolved and are built is also a trade-off or a look at the differences between the cost of integration and the transaction cost on the market. And one of the reasons why firms vertically integrate is also because the transaction cost in the market would be too costly. And your example is just a perfect illustration of Ronald Coase's article of The Nature of the Firm.
Yeah, I mean, in order to know what the outcome of these things is, we're going to have to see an actual statute, which we're still quite some distance from, and see what that statute says. But yes, if that statute requires terms that are onerous, just to make available space on something like the Amazon platform for third-party sellers. Today, by the way, third-party sellers can account for almost 60% of Amazon's business by dollar volume. If the statute makes it too onerous for those firms, for Amazon to deal with those firms, it may simply terminate some or all of them. And that's not going to be an improvement for small business. I mean, Amazon has been a lifeline for small business through COVID because it has given so many of them an internet presence that they would not otherwise have, or that it would have been a lot more difficult for them to come by.
That's true. And this leads me to the questions of whether or not the ban of self-preferring that some lawmakers and some advocates propose, is it protecting the consumers or is it protecting more competitors? You know, this all debate between protecting consumers or protecting competitors. Are we reverting back to a stronger protection of competitors?
Well, maybe. I don't know yet because, you know, we don't have a bill. I don't think every regulation of self-preferencing is bad. I believe there should be a law of exclusive dealing or technological ties. I mean, one of the complaints against Amazon is that it uses non-public information about rivals' products to copy them. Okay, well, first of all, that's fundamentally an intellectual property issue.
Right.
Are these products covered by a utility patent or a design patent? And if they are, then is no longer an antitrust problem. It would be illegal for Amazon to commit patent infringement to copy someone else's property. Now, if they're not covered by a patent, that's going to put antitrust policy on a collision course with patent policy, because the policy of the Patent Act is to encourage duplication of things that are in the public domain that are not covered by a patent. I mean, think of our attitude towards this, and for example, things like generic drugs, where everybody has exactly the opposite point of view. We really need to limit the ability of dominant firms to maintain or extend the patent coverage on their drugs, because we want to make room for more generic drugs to come in. Well, we need some principled way to distinguish them. So why is it so bad if Amazon is going to make a copy of an unpatented device and then sell it on the marketplace for a lower price, which may mean a lower margin? I don't know the answer to that question yet. We just have to see how far this statute goes.
And that leads me to reflect and saying that imitation is also part of innovation, isn't it? To imitate other companies or rivals or some imitation to offer for a cheaper price exactly the same thing that other firms offer. That's part of price competition, isn't it?
Patent law is intended to kind of navigate this boundary between exclusion and dissemination. And when a patent, and it can be a design patent. I mean, some of the complaints against Amazon have to do with its copying the designs of other firms' products, but design patents are protected if there is a design patent there. But if there is no patent protection, then the preference is on dissemination. And so it's a very interesting flip, because in American politics in general, it's been Republicans who favor strong patent protection and Democrats who favor dissemination. And that's why, for example, Republicans tend to align themselves with older, well-established industries that have smaller numbers, but very traditional technologies, while Democrats tend to align themselves with information technologies, internet, computer, networking, and so on, because we place a high value on the ability to disseminate. So those things need to be sorted out, and anybody who's drafting this statute needs to take some care that in the process of limiting Amazon's ability to redesign products to make them cheaper or better, they're not doing a whole lot more harm than good.
Right. I mean, yeah, you wrote a book about antitrust and IP a couple of years ago, where you precisely think about these interactions between antitrust and IP, and that's very complex. But it's all about incentive, providing the right incentive for both innovation and competition, and there must be a right balance to be found with no abuse on either side.
That's right.
That's
right. So I'm a little worried about a statute that may end up being too broad. There are some things that we might want to police, including some abuses. But a statute that simply prohibits Amazon from selling both its own products and third-party products, that's going to be horrible for consumers and labor, because it's going to reduce output and raise prices.
Sure.
To the extent there are abuses, a well-drafted statute should be designed to correct those.
Sure. I think the statute you refer to is one of those, the Senator Klobuchar and Senator Grassley bill, who introduced this bill a couple of weeks ago, where, among other practices, because it's not only the only practice, but basically they ban self-preferencing. But what is more striking is not only that they ban self-preferencing with almost no justifications available for the defendants or for the company, but they ban self-preferencing in a number of practices only for a handful of companies. And because they put a size threshold, rather than looking at the real, as you said, the real competitive effect, which should be the concern for antitrust enforcers, they put a size threshold. Basically, the companies that are above 550 billion of market capitalizations, and as long as they are considered as critical trading partner and have 100,000 of business users on a monthly basis in the US, then they might be considered as covered platform.
This is part of an old mistake. It's in the popular mind, and that is confusing large size with market power.
Right.
And it's a big issue when you're talking about a firm like Amazon, because Amazon is a very large firm. Yeah. However, aside from ebooks and perhaps a couple of other products and a little bit of its cloud service, most of the products that Amazon sells are not being monopolized. It has a fairly small market share. A non-dominant market share, and there are many smaller companies, much smaller companies in the aggregate, but they have larger market shares in particular products. And the self-preferencing thing is, to the extent it causes harm at all, it's going to cause harm with respect to market shares that are relatively dominant. And so in that case, we may simply be aiming our guns at the wrong target,
right?
By making all of this depend on aggregate size rather than product market share.
Yeah, and I think it creates some very discrete line, the size threshold. Like, as I said, 550 billion. What about those companies that are 400 billion? We don't consider a company of 400 billion market capitalization as a small company, I guess. And yet completely exempt from those prohibitions. And how can we treat dissimilarly very similar rivals, right? In terms of competition analysis, it may create or it may distort competition between very similar rivals rather than preserve competition. Don't you think?
Yes, I agree with that.
Right.
I just hope the drafters of this bill or the political process winnows it down so that it's well designed to identify anti-competitive uses of self-preferencing. Now, the Clayton Act did that. When the Clayton Act was passed in 1914, there was a lot of campaigning for very harsh rules against patents, for mergers, and so on. Well, what the Clayton Act ended up doing was putting into the statute a requirement that certain kinds of conduct is illegal if the effect may be to tend to create a monopoly or to substantially lessen competition. And then you leave to the courts to decide whether a particular act of self-preferencing is anti-competitive under the circumstances. So the requirement of competitive harm acts as a narrowing device. Now, I'll be the first one to observe that today the courts have carried that too far. They've developed a fairly strong anti-enforcement bias against certain types of vertical restraints, including vertical mergers. But that really means that they're not taking injury to competition seriously. It doesn't mean we should have a statute that condemns this conduct when it harms consumers and doesn't do any injury to competition at all.
But still, it was a consequentialist analysis. Look at the competitive effect based on the rule of reason with the court decisions. Here it's more not a consequentialist. You could call it like a deontological ethics, where ex ante you look at those practices, and irrespectively of their pro-competitive, pro-consumer effect, these practices are prohibited only for a few companies and,
That's right.
And legal for the rest of the economy. I think it's a dramatic shift of the philosophy that has underpinned.
Well, it would be if that's the statute we end up with. I hope
Yeah.
we don't. The other thing I have a problem with, and this is really a problem of lack of investigation. A lot of this is driven by the assumption that these practices are extremely bad for small business. Well, you know, one of the reasons that this group sometimes calls itself neo-Brandeisian is because they're comparing their thought to Brandeis. Brandeis was very opposed to the chain store, to the rise of multi-store operations. The principal target in the 1930s was A&P, who was a target of the Robinson-Patman Act, but Macy's, Sears, Montgomery Ward's, a lot of chain stores had developed by that time, and they were doing serious harm to small family-owned single store operators. However, in almost all of those cases, those firms were selling only their own products that they acquired or developed themselves in competition with smaller firms. Thanks to the internet, the Amazon story is a lot more complicated and a lot more differentiated. Amazon does compete with smaller firms, and it does serious harm to smaller firms when it displaces their sales. At the same time, however, Amazon acts as broker for many, many smaller firms. As I said a few minutes ago, more than half of Amazon's sales are of third-party merchandise. The firms range from very small to very large, all over the place. But for those, the story about small firms and Amazon is very, very complicated. Amazon hurts some, but it helps others. It helps others a great deal. It gives them access to a distribution outlet that they would not have otherwise. I mean, they could develop it, but it would be expensive. On the other hand, consumers by and large are pretty happy with Amazon. It consistently gets high ratings. And so we need a little bit more than mythology to go on here before we decide what we want to do. What we need is more empirical studies of the question, what is Amazon's overall impact on the various businesses whose products it sells? Because like I say, if one of the alternatives to draconian legislation is that Amazon simply pulls out of the market for certain products, that's going to do a whole lot more harm to smaller businesses than the current situation.
Right, and that's one sentence that I quote from you in the ITIF report when you discuss this aggressive competition that leads to hurt rivals, but competition hurts these inefficient rivals inevitably. And where you say that these practices of aggressive competition are the heart of competition, even though they make a rival's effort more costly. And I think that's right. To aggressively compete, force rivals to respond with higher cost on advertising and raise some rivals' cost. But this is
Right.
not against competition; it's the process of competition.
That's
And
right.
and I don't want to. Of course, Amazon is a clear example of what we're talking about. But self-referencing is much broader than retail. For example, as I referred, the smartphone, like pre-installed app. If we want the smartphone companies not to self-prefer their apps, do we want our phones to come with no apps installed? And because any apps that is pre-installed is competing already with apps that are available on the app stores and that are available on the market. So
Okay, that's a complicated issue too, but
yes,
certain secondary programs are dominated. And the most important one, of course, is Google search, which has a 90+% of general consumer search. It's starting to lose a little bit of ground to Bing, but it's still a dominant one. And one of the reasons it's dominant is because it's the default search engine on both Apple phones, because Google pays a lot of money for that privilege. And it's also the default search engine in the United States on Android phones, because Google owns Android, and its arrangement with its licensing arrangements with phone companies requires that it be the default search engine there. I think that's an area where that default should be re-examined, and I favor the EU decision requiring that Android phones be opened up to choice in search engines. Now, it's a complicated phenomenon because it appears that consumer behavior is very different on desktops and laptops than it is on handhelds. For example, a Windows 10 desktop or laptop today is sold with Bing as the default search engine, but a very, very large percentage of users who purchase a new Windows 10 laptop immediately change the default search engine to Google. So the default does not have a lot of consequence on desktops and laptops. On the other hand, with respect to handhelds, the vast majority of people, it appears, simply stick with the default. And given that large market share, that can cause competitive problems. But the all-important difference between that particular situation and, say, the Amazon story about batteries or toasters or some other product is that Google has a dominant share in search. And as a result, by opening that market up to consumer choice, we can break down some dominance. In the Amazon story, there's typically no dominance in the first place that needs to be broken up.
Right. Yeah, it bears down, what you refer to, it bears down also to the stickiness of consumers to stick to default choices.
Right.
Yeah.
Now the App Store is not a default. That's a different issue.
It's
and
a different.
There, the handheld practice is very different from the laptop desktop practice. If you buy a Windows 10 desktop, you can pretty much buy software wherever you want. You can buy it from Amazon or from Egghead or from any company you want. For the most part, Microsoft does not earn a commission on software sales, and so the secondary market for apps, including games, is quite competitive. The phones, by contrast, and all of them have this feature that the only way you can buy the apps on the iPhone is through the iPhone App Store, and the only way you can buy the apps on an Android is through Google Play. There are security issues that need to be addressed. But I think, once again, that's another area that requires a little bit further study and some re-examination. And, I think we might very well conclude that Apple and Google need to give up their strong positions with respect to control over the app markets.
Right. But there's a lot of, just to refer to the IP discussions we had just a couple of minutes ago, there's a lot of IPs involved, and there's a lot of proprietary assets involved in those investments that have been made, and so that's why also IP laws are involved in not only antitrust, but at least what we cover here shows the complexity and the diversity of a concept like self-preferencing.
Sure, and it conveys a very old message, which is don't condemn something until you understand it. Yeah. And understanding it means first understanding what the problem is, and then understanding the magnitudes. Right. Yes, we know that Amazon can harm some smaller businesses whom it sells. We also know that it causes a lot of consumer benefits by offering in-house and outside products in competition with each other. We need to get a little better idea of what the magnitudes are, and secondly, what the fix is that will permit the pro-competitive uses of intra-platform competition, while prohibiting those particular uses that are bad.
Right. And that's the complexity of the topic that we have before us. But it looks like the regulation, or at least the Klobuchar-Grassley bill, attacks and treats self-preferencing as if it was one practice, well-defined and easy to capture, which of course is not. And there's a lot of unintended consequences of these bills in terms of reaching out on pro-competitive and pro-innovative business practices. But on the bill and on other bills generally, don't you think that that's something that I'm very interested in? Don't you think that there's not a shift from ex post judicial enforcement, as we just discussed, between the pro-competitive, anti-competitive effect, which are necessary discussions to take place in court, toward a more ex ante regulatory enforcement of antitrust, which I call more like a precautionary antitrust, where the reversed burden of proof and the necessity for companies to do no harm before they can ever innovate. Isn't this a shift that is a transformational shift, and that will change the way we do antitrust? Basically, isn't it the end of antitrust to regulate ex ante?
It could be. It could be, once again, depending on what the statute says. But two important characteristics of antitrust are, number one, it's broad. It covers pretty much all of commerce with a few regulatory exceptions. And number two, it begins with the premise that the market should work, and we have to ferret out those individual circumstances where it is not working properly. On the other hand, regulation takes a much different approach. It begins with a small subset of markets, like telecommunications or electricity or natural gas, telecom. Takes a much smaller range of companies and technologies, and then imposes some kind of ex ante regulation on them before they make market choices. Right. So, one of the things we need to do here is keep the boundary specification fairly clear, because are we really passing an antitrust law, or are we just imposing regulation? Okay. And then finally, one very important difference between most regulation and antitrust is the availability, this applies mainly to the US, is the availability of private enforcement. Antitrust law is enforced by private parties through treble damages actions as much, and in much higher volume actually, than government suits. Right. By contrast, most regulation is enforced by a specific designated agency. Consumers can make complaints to that agency, but it's ultimately the agency that decides whether to bring an action. And I would be a whole lot, if there's a certain amount of substantive overreaching in some of this regulation of self-preferencing, I would be a whole lot more comfortable with a statute that assigned responsibility for enforcing that to the agencies, to the FTC, and maybe to the Justice Department, depending on the circumstances, rather than one that simply hands it out to private parties to be their own enforcers, because then I think we would see a nightmare. We would see millions of firms suing because Amazon
rent-seeking.
There's no stopping. Yeah, there's no stopping what could happen if we permitted that kind of situation.
But I think that's very important where you say the premise of antitrust is that markets work, and then we identify those conduct that are abusive and needs to be repressed. And I think the shift that we see toward a precautionary antitrust with, in Europe, the Digital Market Act, in the UK, the Digital Market Unit, in the US, with a number of House bills or even Senate bills, or Section 5 of the FTC that is now looming and that we can anticipate. I think this shift will leave less place for antitrust exposed, because all these companies would be regulated already ex ante. Isn't it a real challenge of the place of antitrust if the economy is so widely regulated, with the premise that firms shouldn't innovate because that would harm the competitors on the first place? Wouldn't that reduce the scope for antitrust on the second place?
If you begin with the assumption that they're going to pass the worst possible bill imaginable, I think all those things could happen.
But in Europe, it could be the case, right?
Could be, yeah, it could be. We just have to see what kind of bill is going to emerge, and I'm not going to get too excited about it until we see what kind of bill we actually have. It's got to claim a majority in both houses. And it could be bad. It could be a lot less bad, just depending on how the political process plays out.
Right. It's a very fascinating time to discuss antitrust, and it was a great moment with you, Herb. Thank you very much for this enlightening discussion on the very complex but yet timely issue of self-preferencing. So I'm delighted to continue this dynamic antitrust conversation series with our next invitees will be Professor Daniel Crane and Andrew Gavil for a discussion on November 12th on the FTC rulemaking authority and Section 5, as we just very briefly introduced that topic. Thank you very much, Herb.
Thank you. I appreciate it.